SJC-13141, Charles M. Lieber, the President and Fellows of Harvard College, and another.
Okay, Attorney Suni.
May it please the court. Good morning. My name is David Suni, and I'm here with my associate, Andrew DeVoulis. We are representing the plaintiff and appellant, Professor Charles M. Lieber. We are here on direct appellate review of Judge Hogan's Superior Court decision denying Judge Lieber's, Professor Lieber's motion for preliminary injunction. We appreciate the court recognizing the expedited nature of this case by granting direct appellate review. It's clear under case law that advancement is a critical right, which if not granted early in a legal process, the right becomes lost forever. And I'd like to provide 2 points of background, but before I do that, because there have been a couple of events that have happened since Judge Hogan's ruling, that is worth the court knowing. But just to briefly summarize our argument, and then I will come back to it. We submit to the court that the preliminary injunction should have issued because Professor Lieber, under Harvard's advancement policy, is likely to succeed on the merits, because at best the advancement policy is ambiguous and requires mandatory advancement, and any ambiguity should be construed against the drafter of the policy, Harvard. Secondly, even if the court does not determine that the policy is ambiguous, we are likely to succeed on the merits under the covenant of good faith and fair dealing. Under the covenant of good faith and fair dealing, Harvard was required in the manner of its performance of the contract to act with an absence of good faith. This is the SJC doctrine.
Can I ask, on the first point, the only ambiguity is they don't use the word advancement in the second sentence. They use the word indemnification. Is that the entire basis of your ambiguity argument?
That's not the entire basis. That's one basis.
Yeah, but I don't find that one very persuasive. I mean, you're obviously, the indemnification is encompassing the whole discussion. I just don't see your point on this, that.
Yeah, so I thank you. I think the Stockman case is instructive on this.
That language is, you keep saying that language is exactly the same. Language is almost completely different, except for it has the word shall in the first sentence, right? I mean,
right. The Stockman language is very similar, and I think well-reasoned.
Similar, how is it similar?
In Stockman, there was a one-sentence policy that said, you shall advance if you provide an undertaking. And then in the second sentence, it said, the general partner has discretion to deny written approval, to deny approval of advancement. So it was, in a sense, it was a mandatory sentence and a discretionary sentence.
I don't see this provision that way. First of all, as I understand it, that's a trial court determination, and Paladinian was contrary to it and was upheld by the Delaware Supreme Court. But putting that aside, the provision says at the end, this paragraph shall not apply if it is determined that it is reasonably likely that the person seeking indemnification will not be entitled to indemnification under this policy. What's ambiguous about that?
Pardon me?
What's ambiguous about that?
Well, so for one, as Justice Kafka has pointed out, Professor Lieber is not a person currently seeking indemnification. He's a person seeking advancement. And what the case law makes clear is that the drafter of these policies has to be very careful to delimit the obligations to advance, and any ambiguity will be construed against it. As Stockman and other cases point out, if you want to make it completely discretionary, you can. They did not do that here. Harvard did not make this completely discretionary. In fact, you don't even have to grant advancement. But what is clear based on a very fair reading of Delaware law, which the court should look to here, is that if you do actually provide advancement, particularly where you conflate the concept of indemnification, whether you're ultimately entitled to the remedy, with the contractual right of advancement, you're going down a road where the court is not going to give you any leeway. And here, that should be the result. And that's why we believe under Stockman and its progeny that the clause is ambiguous and should be construed against the drafter. The other point, Your Honor, is that there is a strong public policy, which we've cited throughout our brief, which actually can be considered on a preliminary injunction, even though this is a dispute between private parties. The court's well aware that in general, you can't pull in public policy, but under the SJC case law, where private party litigation implicates public policy, as it clearly does here. The advancement is a critical right. This is a case ultimately about helping Professor Lieber achieve the right to academic freedom and be free from.
Counsel, let me press you on that because I tell you my takeaway when I was reading that argument, it sounded really arrogant, very elitist, that it's only for these special categories of defendants in white collar crimes that do these really, really important jobs. Do we want to advance this public policy? And if you just happen to be the hack that has a blue collar charge against you, where you equally can't afford to pay your fees, and in fact, you may be denied your liberty if there's a bail that's imposed. And what's the public policy for drawing this distinction to people like your client versus all of the other people that may find themselves on the other side of the Commonwealth versus?
Right. That's a great question. The blue collar person is absolutely entitled to the same benefits and protections of an advancement policy if and when it is issued. If there's no advancement policy issued, nobody gets it, not Professor Lieber, not the blue collar person. But the blue collar person, and we did not intend to be elitist in any way. I can explain the public policy a little bit further, hopefully in a way that is not arrogant. We don't think that it is or intended to be that way. But the blue collar person is absolutely entitled to advancement and indemnification if they're covered by the terms of a private contract, which is what we have here.
Even one that reserves to the employer the ultimate discretion, whether you're looking for advancement or you're looking for indemnification?
So it depends on the terms. If you use the word shall advance, in general, advancement is a distinct right to indemnification. Advancement comes at the outset. So you can,
Sure.
and it is, and I want to also say, Harvard's policy is actually an outlier. When you look at the entire body of case law, it conflates the concept of indemnification with advancement. It allows Harvard's self-interested, potentially conflicted management to with issues that are not legally segregable from Professor Lieber's issues, and that's what they say in their paperwork that they sent to the U.S. Attorney's Office, to make a quote unquote independent determination of reasonable likelihood.
But they control it's a contract, right? I mean, and denying indemnification is a big deal because that's gonna, you rile up the faculty. In a normal case where, okay, you're being sued for an academic freedom issue, the faculty's not a bunch of sort of sheep. They tend to get angry and stand up for their rights. So I get a sense though that this is extraordinary. And I don't see how you get around, the particular exemptions they put in here. Just saying you're innocent can't be enough, right? They've left this determination expressly in their advancement provision to this particular vice president at Harvard. And they also have specific exemptions that seem applicable here. Tell me why just saying you're innocent of the criminal charges is enough.
Well, in addition to saying that he's innocent, Professor Lieber has pleaded that he acted in good faith at all times and he acted without criminal intent.
But they've got a lot of facts that he's not reported the Wuhan contract to them. He's not reported this in his filings with Harvard.
So
Doesn't Go ahead.
So here's a very, very important point. We're at the advancement stage of the litigation.
I get
The
that.
case law that interprets advancement, and when I say the policy is an outlier, there was only one case, two cases that we could find where someone tried to bring in the concept of are you guilty or innocent into the requirements.
I
for
get that
advancement.
Harvard's indemnification policy is very favorable to Harvard, but they drafted it that way.
Right. And so it should be construed against them. To go back to the public policy argument, which if I could just touch on for a minute, the public policy is designed to encourage the most capable of people of serving in important roles. The courts acknowledge that because they serve an important role, that litigation is likely to ensue. The concept of advancement, and it's cited throughout our brief and in the periodicals and in the cases, is a critical right that allows the advancee, the employee, Professor Lieber, to defend himself against those very charges, right? Without a liberal interpretation, and shall speaks for itself. And by the way, Professor Lieber meets the three elements of that first mandatory sentence shall. He is a qualified person, which Harvard admits. He is bringing a claim for things that may be indemnifiable.
I'm not sure how the tax, how about the tax? There are two that severed from that. There's the tax issue and there's a second one,
Yes.
right?
So the bulk of the case involves the false statements charges, which Harvard has admitted may be indemnifiable. Judge Doolin granted motion, but denied Harvard's motion for judgment on the pleadings after we filed this appeal. Harvard moved for judgment on the pleadings, saying our policy is clear. We're entitled to judgment on the pleadings. And most of these advancement cases do get resolved at the judgment on the pleadings phase. And Judge Doolin denied their motion, saying that they had not established that they were entitled to judgment on the pleadings with respect to Professor Lieber's claim for advancement of his criminal defense costs associated with the false statements charges. Okay, so at best it creates a factual issue. As to the tax and the foreign bank account charges, the cases that we cite in the brief show that if those are but for events, in other words, if he was not involved in research in China, then those events would not have happened. They should be considered and included.
But I'm confused. If he doesn't report his earnings on his taxes, that's separate from his teaching or anything to do with Harvard. That's his personal responsibility, right?
Those allegations would not have arisen but for his role as the principal investigator in the research. The cases that address your question,
Meaning he wouldn't have gotten any money if he weren't
allegedly.
a big shot professor from
Allegedly, they're
Harvard.
related charges. The original indictment was just the false statements charges. There was a follow-on indictment. The best example in the case law that we cite is that you can embezzle funds from your employer, which seems to have nothing to do with what your professional duty is. And the courts say, well, you embezzled, you were an employee of the company. And
So every employee at Harvard has the right to be indemnified if they lie on their taxes. I'm confused by that.
only if it arises out of conduct that is covered by the policy in their covered role.
I
If
don't
Professor
understand the
Lieber went-
logic in that. I don't understand the reasoning in that. Like, why would that be so? They're separate acts, even if, no matter where you get the money from,
Right.
right?
Right.
It's still
So-
criminal.
It's a but-for test under the case law. If Professor Lieber had gone out and robbed a bank, that's different, right? These were follow-on charges related to the same facts. They haven't been proven yet, right?
No, I
When-
know,
when
but I
profess-
just
but
don't
so-
understand your answer to Justice Capker's question about the taxes.
Yeah, so,
Right,
so a lot of Harvard professors are consultants. They make a lot of, they get that one day a week or whatever it is. They go out there and make a fortune. They don't report that income on their federal taxes Harvard's required to indemnify them? They've got a contract with a pharmaceutical company. Harvard's gonna have to indemnify them for that?
We don't need to reach that question.
Well,
Here.
just discuss that hypothetical.
Yeah.
Is that okay? That they would get indemnification for that under this policy?
I think it would depend on the facts and circumstances of that case. I don't think
Really?
we need to reach that question here, though.
I'm-
I see my time is up, so if I can wrap up with a couple of points on the argument. The good faith point is very important. The manner of performance which Catherine Lapp engaged in administering the policy, accepting allegations as true, disregarding Professor Lieber's not guilty plea, and essentially relying on the speculation of the criminal allegations and the speculation of her administrators without any kind of due process at all. The manner of performance is critical. It's a violation of the covenant of good faith and fair dealing. All Professor Lieber has to show is that Harvard acted in an absence of good faith, and that all you need to do is look at the surrounding circumstances. And when you do that here, it's obvious that they were self-interested, that they were conflicted, that they were worried about both getting their grant money and not having any kind of a relationship there compromised, as well as not having the U.S. Attorney's Office look at them. So that's a really important point that we think that combined with establishing irreparable harm, which the case law is also very clear. Harvard argues that money damages will somehow be sufficient here. That's not the case. The key point of advancement is it provides immediate relief to the person who has been faced with potentially crushing expenses. And if you don't enforce the advancement right away, the right is lost forever. And so because that right is lost forever, the court has jurisdiction and equity to essentially issue an order, and money damages are insufficient. The other thing I'd like to point out to the
I'm
court.
sorry. Time's up. Okay, thank you. Okay, Attorney Lukey.
May it please the court. I am Joan Lukey, and with me is my partner, Justin Wallace, on behalf of Harvard and Catherine Lapp. You didn't hear much about context here, and I'm going to start very briefly by pointing out that 16 times between 2012 and 2019, Professor Lieber had the opportunity and the obligation to report his outside employment contracts and compensation and lab arrangements. These were required. These reports were required. Conflict of interest reports and activity reports are the means by which the university determines that its faculty is following the policies. That's 16 times.
Can I ask what he did? He did one where he reported that he had over 10,000 in income from something, right?
This was a very interesting one. In 2012, that would make it 17. I left that one out. That's the beginning of the period. In 2012, he reported that he had a visiting scientist appointment, which was not the correct appointment, for which he earned in excess of $10,000. That's all he said. In fact, beginning in late 2011, he entered into a 5-year strategic scientist employment contract with Wuhan University of Technology, WUT.
Can I ask just a factual issue? Like, for example, we have to fill out a form every year, our statement of financial interest. It says our house is worth over a certain amount. It doesn't give us specificity. Is that thing he filed Harvard standard form, you had over $10,000? And would he have been, if he had answered that going forward, would that have been accurate according to what Harvard's asking him to do?
I don't know the answer. I believe, though, that there were levels and that there would not have been an accuracy because the contract I'm talking about was $50,000 a month.
Right, no,
for
I
every
get it.
month.
He's making a giant amount of money.
He's
I'm
making,
just trying to figure out whether Harvard's question allows him to answer truthfully by suggesting he's making over $10,000, so that Harvard doesn't ask because they don't necessarily want to know. So
I would be glad to provide you with that information. As I said, the best I can do now is to say I believe that there are levels, and that would not be the highest level. But if you wish,
not sure of that.
I am not sure at that point, because he wasn't a visiting scientist, which is what they were.
I would at least like to understand whether at least he was accurately responding to that particular form, and whether, if that was the form that was required going forward, was Harvard somehow on some notice of this? But again,
It would have been required annually. I can tell you that, and
So
I will
af-
submit that information.
afterwards, the subsequent years, he's not filing anything.
Oh, he files it. He just doesn't respond that he has an outside appointment of any kind.
So the 16 that you're talking about asked the same question and he leaves it blank?
Correct.
Okay.
Well, they do in the financial conflict of interest form, which is about 9 of them, and the activities report form, they have to say what they're doing in terms of work with other universities. Harvard was more focused. That would be the 17th. I didn't count that one. He was not a visiting scientist. He was subject to a strategic scientist contract for substantial compensation. In 2012, about a week separated from when he filed the form we just referenced, he entered into a second employment contract upon which the government later much more focused, called the 1,000 Talents Program. It is an employment agreement with WUT again. This one is another $50,000 per month for every month in which he works. And this one required that he work at least a certain period of time for each year for WUT. Now understand, he was supposed to be a full-time professor at Harvard.
Yeah, but full-time professors at Harvard often have ability to earn outside money, correct?
As long as they report it and get it approved. What they don't have, I can tell you with assurance, what they cannot do is accept another full-time teaching position at another university.
But
They cannot do
this
that.
one, I understand this is complicated, but is his Wuhan appointment a full-time? Or is he getting a fortune for sort of an unspecified amount of work?
Well, one of the
Does it
three,
say, for example, does the Wuhan agreement say it's a full-time agreement for him?
well, one of the three says it's got to be a minimum of 9 months a year. For faculty, I count that as full-time, Your Honor.
But 9 months a year, I mean, if he shows up 9 times for 1 day or 3 days, by the way, what is does the record contain what a Harvard professor is allowed to do outside of, I mean, a number of universities have this 1 day a week provision. Does Harvard have something like that?
They have a policy, which is in the record, which states that they cannot be involved in employment at another university without approval. I do not require the policy, and it says they can't be full-time at another university ever. That will never
No,
be
I get
approved.
that. You can't be full-time in 2 different places.
Right.
But
But the point is, he puts one time that he's a visiting scientist. That usually means you're there for a few weeks or a few days, and he gets a compensation over 10,000. He never says it again. He enters into 2 more contracts, each as lucrative as the ones before it. Gets worse. And this goes on 2011, 12, and 13, 3 contracts, each of which is for 5 years duration. So it's hard for us to know because, of course, he hasn't been deposed, whether they overlapped, whether they were on top of each other. What we do know is in 2018, the National Institutes for Health contacted Harvard and said, we want to know what's going on with Charles Lieber. We think that he's in the 1,000 Talents program in China, which is something that the government was sensitive to because it involves a requirement that the faculty help promote China and its science programs. And we don't permit that to people who have grants from us. This is NIH. Harvard goes through all these reports, sits down with Charles Lieber in November of 2018. He denies that he has any affiliation with WUT of any meaningful kind, says he has visited on occasion because he has former doctoral students who are in residence there, but says he has no teaching contract, has never had anything to do with the 1,000 Talents program. Harvard, therefore, writes a detailed response to NIH saying, you have bad information. Somebody must be out to get Charles Lieber, is essentially what they
So
say.
at the time he makes that, does he expressly say does he have that 1,000 talent contract when he makes that representation? I can't remember, there's some timing issue, right? Or is it crystal clear that when he says he doesn't have a 1,000 talent contract, that he actually does have 1,000
Well,
talent?
they didn't ask just in the present tense, because the question from NIH is, has this man had any participation with the 1,000 Talents program, which is a sensitive issue? So they ask him if he's ever had any involvement with the 1,000 Talents program, and he says no.
Right, but again, I'm trying to be specific.
Well, we don't know if he
does-
was
Is
still
it the
in.
time he hasn't, again, I can't remember the briefing, but I remember there's some ambiguity in that he's been nominated for this and not gotten it, or is that not true?
That's not true.
Okay,
He was in the 1,000 Talents program. It is a multi-year program, but in terms of how many years, again, he hasn't been deposed. We have to go with the record. We know he entered into it in 2012, and we have no way of knowing at this point whether it was ongoing in 2018, but certainly we know that they were multi-year programs. The one in 2011 was for 5 years, one in 2012, we believe, which is the 1,000 Talents program, was for 5 years. And then the subsequent one was a lab in which he purported to sign for Harvard. And it was called the Wuhan Harvard Laboratory of Nanoscience.
Yeah.
He had no authority to do that. Harvard did not approve it. And the emails, if you look at the ones we referenced in our brief, he writes back to one of his colleagues in China in Harvard's email system saying, I'm going to try to stay away from this with Harvard, and I'm not going to tell the government anything about this.
So, Counsel, if I could, so all of these things set up why the prosecution happened and why now Professor Lieber saying, I'm incurring these. I just would like to get to that part about the terminology here and talking about this ambiguity between the advancement versus indemnification.
Thank you, Your Honor. There is no ambiguity whatsoever. The indemnification policy provides that certain individuals are entitled to be indemnified. There is a carve out for faculty who are involved in teaching, writing, and research. It is not guaranteed for them. It says it right in the policy. It says that's purely discretionary. You have so much autonomy, faculty members, in this area, that we're not giving you this indemnification unless we feel it's justified. There are also 5 exceptions listed in the indemnification policy, one of which happens to be if the professor violated policies of the university. That is extremely important because it's one on which Catherine Lapp actually predominantly relied in determining that she could not agree to advancement. Now, the advancement policy on its face is perfectly clear. There are the opening sentences that say that the university shall pay or reimburse counsel in certain circumstances, but it's a 1-paragraph advancement policy. The second sentence is, this paragraph shall not apply if it is determined that it is reasonably likely that the person seeking indemnification will not be entitled to indemnification under this policy. So that falls to the executive vice president, Ms. Lapp. She looks at the circumstances.
But do you see that the use of 2 different terms, that you go from advancement to indemnification, may at least arguably say that there is an ambiguity here because they're 2 different things.
Well, it's in a paragraph called advancement policy. It has a title. There's the indemnification policy, which the corporation adopted only 10 months before this lawsuit was filed. So many of these events occurred before the policy existed at all. In the indemnification policy, it describes who will be covered, and it sets forth the 5 exceptions, and it says that faculty are not going to be covered unless the corporation decides out of the goodness of its heart to cover them if it relates to research, writing, and teaching, which is what we have here. And then there is the advancement paragraph. which provides that they will advance the fees to covered persons and qualified persons in covered roles, but they're going to make an advanced determination as to whether it is likely or not that the person would be indemnified.
Okay.
Now, why are they doing that? They're doing it because they're a nonprofit organization. It's not their own money to willfully give away, as a public corporation might choose to do. There are 18 states, as we pointed out in our brief, that by statute require at least their nonprofits, sometimes all their corporations, to determine before they advance funds, because they know getting it back can be very difficult, whether it's likely the person will ultimately be indemnified. We don't have the statute in Massachusetts, but Harvard chose to add that provision into its indemnification policy so that it would not be giving away its donors' funds, its charitable funds, in a circumstance like this, where the professor very nearly got Harvard in the line of fire for the US government because they submitted a false response unknowingly. When they then were called upon to pull the records, that's when they found the emails, which demonstrated that he did enter into these employment contracts, including the 1,000 Talents program. That's when they had to go hat in hand to the government and say, we're sorry, we misled you, and lay it all out. Those are circumstances under which it is highly unlikely that an individual is going to get an advancement from his nonprofit charitable university for conduct that almost got the university into the same trouble that he was in by virtue of his lies to them. They did not prejudge and did not make any attempt to affect his criminal proceedings. And indeed, at the judgment on the pleading stage, that was stayed. The court said, don't deal with that. And Harvard was fine with that. They're not trying to influence what happens to him in the criminal proceedings. What they are saying is, we do not believe.
How do you deal with their argument, which I think is one of their stronger ones, which is he's being federally prosecuted. The federal government's coming down on him. He can't defend himself very easily here. So he's without potentially incriminating himself. So he can't really present the information to you to get the advancement. I think that's the gist of what they're arguing on that.
I understand, Your Honor, but remember, they've got his conflict of interest reports, which are false, and his activity reports, which are false, and they have his emails confirming that he entered into the contracts and that he was receiving funds abroad and was directing them to put it in a Chinese account so it couldn't be tracked. They have all of the contemporaneous words. Those actions all violate their policies. They're not trying to influence what happens to him criminally, as I said, but there will be no question, just on the basis of the written record that they possess, that he violated their policies against outside employment, failure to report outside income, use of the Harvard name without authorization on a laboratory in China, and the like. So they are in a position where they already have the information, regardless of what he says coming forward. He may try to justify why he entered into contracts and took money and named a lab using Harvard's name, but he can't explain it away. It is confirmed in writing, and documents do not lie, only people do. I believe my time is up.
Okay. Any other questions? No. Thank you very much.
Thank you very much.